Welcome to our podcast on the common issues encountered in purchasing landed estates. I'm Adam Corbin. I'm a partner with the agriculture team here at Michelmores. I act for a broad range of institutional and private clients, mainly on contentious matters. I'm joined today by three other partners at Michelmores. First of all, Chris Massey. Chris specialises in handling sensitive and complex substantial landed estate, agricultural, country house and high-value residential transactions. We're also joined by Jennifer Ridgeway. Jennifer acts for individuals and their families in all aspects of structuring their private wealth, including advising upon succession issues and tax planning. We're also joined by Ben Sharples. Ben advises upon a broad range of contentious agricultural matters, including landlord and tenant disputes over agricultural and residential property, partnership disputes, real property disputes, and professional negligence connected with these matters. Well, that brings us nicely on to our fourth topic, which is public rights of way. There's probably in my practice, I spend maybe at the moment 25% of my time dealing with opposing mainly applications to register new rights on the definitive map. So what we're seeing a lot of at the moment is a lot of activity from the Ramblers because of the Lost Ways project. And that's come about because of a change in the law, which says that from the 1st of January 2026, you're not going to be able to make applications to modify the definitive map on the basis of uncovered historical information. And so that means that the Ramblers have spent quite a lot of money on publicising this change in the law and encouraging people to make as many applications as possible. And so up and down the country, local authorities who are in the main the applications to whom the people to whom applications are made are having to deal with a huge volume of applications to create new public rights of way or to put public rights of way back on the map. And so there's a sort of terrible backlog in some areas of up to 30 years for dealing with public rights of way applications. So that means that even though applications will have to cease after the 1st of January 2026, we're probably going to be seeing local authorities having to deal with these applications for many years to come after that. Quick reminder, there's several ways of applying to have a public right of way put on the definitive map. You either say that the way has been expressly dedicated, or there's an implied dedication because the landowner has done something in the past, or there's a dedication by 20 years use. This 1st of January 2026 deadline only applies to applications based on some sort of historic implied dedication, not to dedications under 20 years use. So, Chris, what do you tend to do about these applications or the possibility of these applications arising?
Acting for a purchaser is rather tricky, to be honest, as to how you can come up with a definite solution to a potential problem. I think the very best that we could do is ask the questions. So does a vendor in some way know something that may be of assistance, that might provide us with a bit of a heads up that we've got an issue? Searches in themselves aren't going to help us much. Again, the site visit may come into its own, because at least we can see on the ground if there are potential issues, and we do ask questions about whether people are heading off down different routes, and whether other things have been established, whether statutory declarations may have been made and submitted to the local authority to record how public rights operate. But there's no simple definitive answer. It can quite often be a bit of a problem when we're hitting a deal and the public rights of way are not quite as they should be.
Yeah, and just picking up on that point, it's worth stressing, isn't it, that, a Section 31 declaration that, as junior agents, you cut your teeth on getting your red pen out and stating all the public rights of way that you recognise on an estate and then submitting that, that isn't going to stop, you know, a lost rights application. If they uncover some evidence and bring an application under that heading, it's going to stand on in its own right, and any submissions under Section 31 aren't going to head that off.
Yeah, I mean, the current trend in applications is to uncover quarter sessions, diversion orders between 18 and 1900, or court leet documents from the 1600s that refer to, you know, a public right of way in a particular location. And so there's not much you can do as a landowner against those, because often that is the only evidence that there is, and it can be a little bit depressing. On the other hand, TVGs, do you come across those very much, Chris?
It's a really fast train in France.
I was going to say, I have ridden on one before. It was very nice as we rolled into Gare du Nord.
Village greens.
Have I come across them? Yes, I have come across village greens. Common land can also be a particularly interesting situation. It can present its own challenges when it comes to crossing the green to actually get to a particular drive or an entrance. It's probably where you chaps come in, I would have thought, to help on that front.
Yeah, common land is something that often takes a long time to unravel, and it often results in an unsatisfactory outcome for all concerned, really. We've had a lot of interest recently, though, in landowners making declarations similar to under Section 31(6) of the Highways Act. You can make a declaration under 15A of the Commons Act that says that you don't recognise any village greens on your land. And that triggers a period of a year in England or 2 years in Wales for an objection to be raised by somebody who thinks that you're wrong and thinks that an interest has been created. And they're very similar in the way that you deal with them to public rights of way, in that there's a decision by a local authority followed by an inquiry of some sort, and you're looking at use as of right. But in this case, you're looking for use for lawful sports and pastimes, including blackberry picking.
Gosh, I mean, what I would say is, and actually this is a general point for any potential quirks and issues that it might be difficult to resolve on an estate, is we talked before about indemnity insurance and the possibility of getting some sort of monetary cover in place. A huge proviso there is, as soon as you start following a route where you're going public and you're seeking a means to try to resolve a problem, that is that you're not going to be able to get the insurance cover in place. So insurance companies quite understandably don't want people probing, and at worst you may find that there's a far greater, at best you may find that there's a far greater premium that you're going to be paying. At worst, the cover is completely and utterly negated and gone. So the solution is lost. And I guess the difficulty here is, for a purchaser, you do ultimately, one hopes, intend to actually purchase the landed estate and actually want to get stuck in with your estate, rather than creating a problem that just can't be resolved. So it's very tricky. It is a very difficult decision to take, and balancing that potential hassle in the future with wanting to get cracking and get on an estate.
Yeah, I think with the TVG applications, it is a real, or declarations, there's a real risk of poking the bear and making matters worse, because you've put your head above the parapet. And the reality is that you can nearly do as much by preventing access physically on the ground, and by signage, and by, if not preventing access, permitting access expressly, because then you're removing the presumption of by right. Which I think in many instances is better than going along and making the declaration. Although I think the 31(6) declarations for highways are definitely still worth doing, because they're rather more commonplace and they don't trigger the right to make an application and call into question the existence of the green.
but it's an absolute bugger when it comes up. And actually, in this neck of the woods, there are villages in the Cotswolds that every single one of them crosses over a village green or common land to actually get into their properties.
It's such an arcane area of law as well. I mean, it's, you know, property law in general is fairly labyrinthine, but this is the far reaches of the catacombs when you get to the commons stuff.
Yeah, yeah. And there's no costs, so people can make these applications and, you know, be comfortable that it's not going to cost them anything if they lose.
Anarchy. That's what you got there, Adam.
But I mean, did you find with the manorial rights and the sort of chance of repair thing? I mean, that was a bottomless pit of misery when that was rolling through, and it was people destroying generations of good relations with villages by slapping down all of these applications. And really burning bridges. They were never going to be able to get them back.
And for what benefit when it comes down to it? I mean, they were fired up by a few lawyers who thought, you know, well, this is a great opportunity to get something for nothing, without pausing to think what that something they were getting was, and was it worth the breakdown in relationships, as you say.
We had a brilliant thing in the other day where the estate was wanting to make 31(6) declarations, but they'd already defeated a TVG application because they'd closed this land for foot and mouth, and it just really neatly severed in half the 20 years.
I had one like that, and also one where they'd requisition the land for radar and searchlight sites to stop bombers coming into Liverpool on the flight path into Liverpool docks. And we could demonstrate that by MOD order, no one had gone anywhere near the site, otherwise they'd have been shot. Pretty effective.
But I reckon diversions are coming round. I think people have been too afraid of making applications for diversions, and actually there's starting to be more case law on whether it really is reasonable for the local authorities to turn down the applications. And the house builders seem to have been really successful in applying for diversions, mainly because they dress them up in a planning application, and, you know, there's additional power within the within the team.
Because there's additional reasons why it's in the local authority's interest to get those houses built.
Yeah.
I mean, Adam, Ben, are you finding that, I mean, has COVID had an impact with work from home? I mean, it's had an impact on local land charges and planning generally. I mean, has it just slowed everything down to snail's pace?
Well, anything like that, the land registry, local authorities, I mean, any branch of local government, I think, you know, it was creaking before. I mean, now it's virtually ground to a halt, as far as I can see.
Yeah, well,
the same is true of the Office of the Public Guardian and HMRC.
On the planning inspectorate didn't run any inquiries for public rights of way for I think for 15 months. They didn't run any at all. No virtual ones, nothing.
So is there a huge backlog now then that people are working through?
Yeah, but that's brilliant for landowners.
Yeah, it's great. We're dragging them out forever now. Thank you for listening to our podcast. If you ever have any inquiries which you think that Michelmores could help you with, please contact me on adam.corbin@michelmores.com. The next mini-series of podcasts will be covering voting rights on the rural estate. This will include discussions on reservations, leases and licenses, in-hand enterprise issues and structuring, and VAT and other taxation issues. See you then.